Every day in the USA, people find themselves in court.
Most of the time, yes.
Yes. Oh, thank you. Yeah.
Just get hands on yourself.
Okay, right. Thank you.
All right, good afternoon. We are on the record in the 53rd Circuit Court for the County of Sheboygan, and we are providing public access both in the courtroom and online. We're here for oral argument in a zoning appeal that's contained in count 10 of a civil action, that being Johnson v. Northern Water Solar Park in Sheboygan County. It's filed 25-9153CH. Counsel, you want to state your appearances beginning with plaintiffs?
Good afternoon, David Delaney, counsel for the appellants.
Good afternoon, Catherine Kaufman and Michael Vila on behalf of Sheboygan County.
Okay.
Good afternoon, Your Honor. Larry Opaleski on behalf of intervening appellee Northern Waters.
All right. Good afternoon. All right, and I have had a chance to review the record on appeal, the briefs on appeal, including the reply brief and the attachments. So thank you for that, everyone, so that I can be prepared for what we've got here today. Mr. Delaney, go ahead with your oral arguments.
Thank you. Judges, my recollection that the court afforded an hour time for these oral arguments, and so I want to be respectful of the court schedule. If that's the case, I think that each counsel would have about 15 minutes, and I'd reserve the remainder for rebuttal.
Yeah, you know, I'm not super strict about time here, so we'll take the arguments as they need to be fleshed out. So,
Okay, I've divided my.
I promise you, if you take longer than I want you to be taking, you'll know it.
I am well versed in the court's approach to advocacy in the courtroom, and I'm ready to go.
All right, go ahead.
I've divided my appellate arguments into three areas: the constitutional claims, the party aggrieved, and the planning commission record. And I can delve into any of those areas if the court has an order, but that's the order I'm going to go with that. The constitutional claims, I'll begin there. The court previously dismissed the non-appellate constitutional claims in this case. I candidly disagree with that. But in any event, I think that the Michigan Zoning Enabling Act allows me to re-argue or to assert the constitutional claims. I recognize there's tension between the MZEA 125-3606 and 125-3607 and the applicable court rule MCR 7.122 because the MZEA indicates that the court can look at constitutional questions where the court rule does not.
Well, but I mean, the court rule says that I reviewed the decision for whether it was authorized by law. Presumably, if an action violated the Constitution of the United States or the state of Michigan, it would not be authorized.
Okay, and I appreciate that approach. I never know where the court, what the court might be thinking about something. I'm going to be brief on the constitutional claims because I don't think it's the core basis of my arguments here. But there are equal protection claims in this case. Sheboygan County has 20 zoning districts. 5 of those allow level 3 solar and 15 do not. The 5 that do allow are the commercial development, light industrial, general industrial, ag and forest, and lake and stream. Which one of these is not like the other? On an equal protection claim, are there natural distinguishing characteristics that would permit the zoning? And secondly, are all persons of the same class included and affected alike? Somebody in the Lake and Stream District is not going to have any similarity to somebody in the Industrial District at all. And it's unclear to me why the Planning Commission, or excuse me, the Board of Commissioners permitted those districts to be created for level 3. And I believe that those districts are unconstitutional because they violate equal protection. So there's my argument on the Constitution. I don't want to elaborate further because I believe that there are more meritorious issues to be looked at. Now, aggrieved party. I believe that the greatest amount of attention will be spent on this particular area. The defense argues, both defendants, EDP and county, that by submitting affidavits, we're expanding the record. It's a closed record. You can't submit affidavits. Now, to me, that's a fundamental misunderstanding of zoning law. Let's look at the Saugatuck case. Saugatuck case is a condominium development on the dunes in the Saugatuck area, and that's a planning commission case. The developer went to the planning commission, he made his case, or they made their case, or she made her case, and the neighbors and or the Saugatuck group objected to that. Now, in Saugatuck County, you have a horse of a different color. Their ordinance allows you to go to the ZBA. That's your first appellate body. Your next appellate body is the circuit court. We don't have that in Sheboygan. That's not in dispute in this case. The Sheboygan County zoning ordinance does not have a mechanism to allow an appeal to the ZBA. Now, it's for another day. I don't think that the executive branch should have a judicial feature to it where they're hearing appeals out of the planning commission. They're in the same branch, but that's for another day. The county is suggesting that we were to submit our affidavits at the planning commission level. You're not an aggrieved party during the planning commission hearing. A party is not aggrieved until after the decision. A person or a party aggrieved by a decision. So you're not going to have people coming into a planning commission hearing, filling out affidavits saying they're an aggrieved party. During the deliberation process of the public and the planning commission is when the decision is made. Once that decision is made, then you are an aggrieved party. So there has to be an affidavit. If we take this to fruition here in this case, you'll never have any appeals because no one is going to file an affidavit that they're an aggrieved party during the planning commission case. They can't. That board lacks jurisdiction. They're not an appellate body. This court is, and so would a ZBA. So if you look at Saugatuck, there are no affidavits filed during the planning commission hearing. Because of the ZBA component, the Zoning Board of Appeals appeal process, the plaintiff's appellants in that case, the neighbors, if you will, filed an appeal with the ZBA. It was then that the affidavits were filed. So that was their first appellate body. But they didn't do so because until the developer challenged their aggrieved party status. And the ZBA said, no, you're not aggrieved. We don't think that you meet the criteria for that. There are multiple appeals in that case, multiple ZBA hearings, multiple circuit court actions, and multiple appeals, but it was all consolidated by the Michigan Supreme Court. But in any event, the bottom line is that our aggrieved party status did not begin until the planning commission ruled. Then we were aggrieved, and then we came here and filed our affidavits. So the argument doesn't carry any water in this case.
And you're not saying, are you, that I mean, you couldn't by affidavit expand the record from which this court would review the merits of the planning commission's decision?
I agree with that.
Okay.
So I
You're
bring
just saying you were submitting materials for this court to properly address the question, the threshold question of standing. Are these parties, do they have standing to bring this appeal? Are they aggrieved parties?
That is correct.
Okay.
And there's some overlap there. For example, I couldn't bring an engineering report in to say that the planning commission shouldn't have approved EDP because I had this engineering report I'm giving you today.
Yes, yes. You can't say here they made this factual finding and it's contrary to this report that I'm going to give you now.
Exactly.
Okay.
There could be some brief overlap in the sense that the aggrieved party status, the person submits an affidavit to show why they're aggrieved. But the Saugatuck decision spends a significant amount of time, especially at the end of the decision, and they say, look, if you have any questions about aggrieved party status, reopen the record or take further testimony, but not on the planning commission decision. That is a closed decision. And that's all laid out in MZEA 125. 3604, which is your ZBA, 605 is ZBA, 606 is ZBA to circuit, and then 607 is any order of decision. But Saugatuck said at the very end, we caution the courts not to overly construe allegations of aggrieved party status. They want you to rule on the merits. And doing a lot of zoning and representing developers frequently, candidly, we'd rather not have the neighbors. But the Supreme Court is saying let them in if they can show a nominal standard as an aggrieved party status and just get to the merits. That became evident because in 2023, the Tuscola decision came out. Now think about that. The Supreme Court, Michigan Supreme Court, took 2 aggrieved party cases in a year. That's pretty substantial because they're handling criminal law, they're handling personal injury, and they wanted to put their foot down, in my estimation. In Tuscola, the airport said that we're opposed to this wind energy, which is ironically a renewable energy that we're dealing with here. And if you look at Tuscola, which is a small airport, but the pilots spend about $262 a year. I don't fly, but it must cost to land there, and you get some food, or you have to put your plane in a wing area in a hangar. But in any event, there's no contesting what they said in Tuscola. $262, one less plane is enough because it is a possible pecuniary loss for potential harm. I also cite the Beverly Hills racket decision 2024, unpublished, so I didn't want to give it a lot of weight, but they say this: Saugatuck Dunes is a low bar. So they want you to let them in, particularly if they're contiguous neighbors as we have or nearby neighbors. But in Beverly Hills, it was a daycare, and the Planning Commission or the ZBA approved a daycare across the street. And Beverly Hills said, look, if they have one less kid going to the daycare, that's a possible pecuniary loss. That's how low the bar is in this case. Consider this case, which is in the record, 1,700 acres across 32 parcels, including 275,000 solar panels. The affidavits we provided in this case are from Johnson, Dwayner, Long, Compton, and Wisniewski. Those are the core affidavits because all of them participated to some degree or another at the Planning Commission level. Mr. Johnson, who's seated here, sent his daughter, who has power of attorney, and that's in the lower court record, in the Planning Commission record, that they spoke. And they gave affidavits indicating that Johnson, for example, will be completely surrounded by the solar panels, north, south, east, and west. Betty Johnson is 84 years old. She has congestive heart failure. She has a pacemaker. Robert likes to hunt. He's going to have decreased property values. They're going to miss their quiet enjoyment. The PAFS, the drinking water, the endangered species. So
the protected interest that you're asserting makes your clients agree, or at least some of them aggrieved parties, is their interest in their real property and the quiet use and enjoyment of that?
That's correct. And if we were in the nuisance case, the court has a whole different perspective. Now I've got to prove that those may be actual harms that here, but not on the aggrieved party status. It's really a low bar. They're letting, even if you're renting an apartment across the street from a solar project, you have standing to get in. And that's why the Supreme Court stepped in again in Tuscola and said, yeah, one pilot, 362 or 262 a year. I mean, $262 is enough for standing. Some would be surprised by that. I'm actually a little surprised, and he didn't even lose the money. The airport hadn't even lost the money, and nor did the daycare in Beverly Hills. These are projects that aren't built. So it's a different analysis than it is for the nuisance claim, which they argued it wasn't built, and that's off to the Court of Appeals. But here in Saugatuck, the condo wasn't built. The airport didn't have the towers in yet, and they hadn't built the daycare, but it was enough to get in. And I think the Supreme Court has been pretty clear about what they want to accomplish. And the test is light too. Just take a position by letter or oral public argument. So Wisniewski did that. He sent a letter in, but he didn't appear. But Dwayner, Long, and Compton did. And that's in the minutes from the July and the August meeting, mostly the July meeting. That was the one that was the most heavily attended at the high school. Counsel for ADP and the county and myself were there for the July and the August meetings. They probably didn't know that at the time. They didn't know me. Secondly, some property right, just have some property right, likely to be affected by the decision. So again, light standards. Third, some evidence of damages, likely injury different in kind than others in the community. Well, certainly Johnson is going to be affected by this because he's completely swarmed, it will be swarmed by these solar panels, different than somebody in downtown Sheboygan or another jurisdiction within the county. So I think that what I would like the court to take away from the standard as it relates to an aggrieved party is, number one, it's a low bar, and
Yeah.
we've met that standard.
Perhaps, I mean, I'm starting from a position as I read these briefs that, I think it'd be a strange result indeed if I were to hold that your clients could press a private nuisance claim because this development may well constitute a private nuisance to their property rights, but they're nonetheless not aggrieved by the special use permit. So at this point, I think they're aggrieved parties. So maybe anything further on that you can reserve for rebuttal argument if the appellees persuading otherwise. But if you want to address now the merits of the decision from the Planning Commission, was it authorized by law and were its findings supported by competent material evidence?
In February of 2025, Sheboygan County amended the regulations in their ordinance relative to solar energy systems and level 3 and level 2 and level 1. We're concerned with level 3 here. And then after the day after this court ruled in January, the Board of Commissioners rescinded that ordinance. So it's no longer on the books and entered a moratorium. The legislative branch, when they amended that ordinance, was free to amend without any restrictions. They were represented by counsel at that time. There was no pending litigation. There really wasn't a lot going on in the community as far as solar, and now there is. So nobody was interfering with their ability to amend this ordinance, which sometimes mistakes can be made when you're being pressured. The Michigan Zoning Enabling Act, 125-3504, states the standards shall be specified in the zoning ordinance, and they are. 3501 says the decision shall be based on those standards in the ordinance. And 3502 says the decision on a special land use shall be incorporated in the statements of findings. That's the most critical one that we look at. So for reasons that I don't know, the Board of Commissioners amended only one section of their ordinance, which the court has a copy of, and that's section 17. But those are the supplemental regulations. Unclear to me why the planning or the Board of Commissioners would amend only the supplemental regulations. There's voluntary regulations in there too, but they all relate to 17. Article 18 is the core special land use permit procedure for standards. In other words, some businesses are under 17, but not all. A daycare may not be, but a factory might.
They all have to meet the Article 18 standards.
That's correct. That is correct. But 17 applies to maybe the little more notable projects, the construction projects involving trucks, industrial, things like that.
So do I understand your argument to be not that, as I look at the Planning Commission findings of fact, not that a particular finding was unsupported by the competent material evidence on the whole record, but that the Planning Commission failed to make certain requisite findings?
Correct.
Okay.
Made none. 20 is the site plan review, and that I would put that under 18. 18 is the most notable section in there. And 18 says another shall approve or approve with conditions only upon a finding that there is not a substantial negative impact on the natural resources of the county and other conforming properties in the area. Let's say they looked at 18 and they found that. That's where the courts are going to be looking at you to say, don't be the super zoning commission. They looked at this. They found that this was not a negative impact. And, you know, the court had a similar case in the Hope case, which counsel was involved with, and they did look at 18, but they omitted any reference to the road, as I recall. So even when they looked at 18, this court still said, yeah, go back and look at the road and then go from there. They didn't even touch 18 here. And then 20 is site plan. Shall approve or approve with conditions only upon a finding that the proposed site plan complies with all applicable provisions of this ordinance. And the last amendment to 20 was in 2022. 18 was last amended in 2023. Again, why the Board of Commissioners, if they really only wanted 17 to be the controlling regulation for solar, they had to fix 18 and 20. what they did. Article 9 is your ag and forest. That was last amended in 2019 because we're in an ag and forest zone here. And Article 10 is your lake and stream protection. Both of those sections say that the special land use permits, which everyone agrees we have, are subject to 18. So they had to go to 18. Now, don't take my word for it. EDP applies for a special use permit and they cite Articles 9, 10, 18, and 20 in their application because they read the ordinance and they knew what they had to do. The Sheboygan County accepted that application, and that application is filed with this court. In the brief of EDP, they admit that 18 and 20 govern this project. Sheboygan County publishes notice of a special land use. They have a public hearing in July and August of 2025. The zoning administrator revised his staff report, and I'm not giving this a lot of weight, but I just don't know why he did that. And when he amended it and revised it, he took out, the first one says they're subject to Article 20, which is the site plan. The special use permit language is gone too. I don't know why that was taken out. Maybe he thought that they only had to comply with Article 17. The Sheboygan County Planning Commission issued its findings of fact on August 6, 2025. Those findings of fact exclude any reference to 18 and 20. Zero.
So what should I make of, it seems that the briefs of the county and the developer, they don't point to anything, because they couldn't really, anything in the findings of fact for findings under Article 18.
Right.
But they seem to argue, well, but the standards in 18 seem to be otherwise satisfied by, you know, the either the general findings or the application materials submitted by EDP that were referenced by the Planning Commission in its findings. What do I make of that?
Okay, so I expected them to make that argument. Let me walk into that this way. Counsel for the county has said at prior hearings, you aren't the super zoning commission. And I think everyone knows that case law. So what they're saying is, if you look in the bag, Judge, of EDP's applications, and they are extensive in this case, you'll find support for 18 and 20, but that's not the test.
Oh, so you're turning that right back on them. I'm not a super zoning or zoning authority, so I don't get to go dig in the facts and make findings.
Precisely. But look at this. Counsel for the county likes MCR 7.122. She believes that's the only appropriate court rule. So 7.1, so we'll do that. 7.122G, as in girl 2, says the findings. See, it's the findings. Yeah, the whole record language is in there. Look at the whole record. I agree. But the port, when the boat comes into port, it's the findings. You have to find, and then the MZEA talks about decision, but the core language is the findings. Did the Planning Commission make findings, yes or no? And they didn't. But you'd be swimming in the sea, if I may offer that, Judge, if you were to read this record and in your opinion, think that they complied with 18 and 20. If the Planning Commission had done that, then I can come to you and say, here's what the Planning Commission said about 18 and 20. I disagree with that. Most of the time, the court says, look, I'm not on the Planning Commission. They looked at the reports. They didn't think it was going to be a substantial negative impact. Don't come to me. Kind of some of the arguments you made to me when we were here in January. The court has its lane of travel as the judiciary, and so does the legislative branch. In this case, it's the executive branch. And I think it's as clean as that. Look at the Beck decision. That's from 2024. The Planning Commission must make factual findings underlying its determination that the ordinance was satisfied. I mean, that's pretty clear. Did they address 18 or not? Look at, and I didn't brief this, but it came up when I was researching issues recently from the county. Section 21.3 of the Sheboygan County zoning ordinance says with absolute clarity, no permit shall be issued except in strict conformity with the provisions of this ordinance. How is the county going to get around that language? They issued a permit and didn't address 18 and 20. The other thing is, look at the item 10 the planning commission approved minutes. This is the August meeting where the EDP got approved. There were two cases before. A special use permit for indoor storage facility and another indoor storage facility. So you look at the minutes, which is in this court's record. The indoor storage facility says the planning commission reviewed section 18 and 20. Next case, McPhee. The first case was Barber. McPhee, indoor storage facility, planning commission reviewed the findings of fact. They made findings under 18 and 20. Last case on the docket, closed session, attorney-client meeting with the planning commission. They come back out, they rule on 17 only. How can they explain that? When the ordinance doesn't say that 18 and 20 does not apply to solar power. It doesn't say that. It's unamended, and maybe they intended to amend it. Now, they do reference 9 and 10, but 9 and 10, which is the two zones, tell you to go to the special use permit section, which is 18 and 20. So what we're asking the court to do is not weigh in on whether, as the court said in January, maybe the county likes solar. And maybe the court likes solar. Maybe the court doesn't like solar. All you're asking the planning commission to do is to go back and apply 18 and 20. If they do that, then, and they issue the permit, then I have to come back. But they have to make findings under 18 and 20. Now, the other thing is the Board of Commissioners can decide to amend their ordinance again and simply say 18 and 20 doesn't apply to solar. Okay, then we're back to 17. And then they're going to make the findings under 17. And that may be a clearer path for EDP. EDP could say, look, and I think the court would stay out of it because that's what you indicated in January. It's not the court's province to weigh in on the legislative branch. They want 17, then say that, and say 18 and 20 don't apply, and then approve them. I mean, we're going to come back again anyway. And there's a moratorium, I recognize that. But I think all the court can do is send it back to the legislative branch to say, what do you want to do? And planning commission, apply 18 and 20 and come back and see me, which is what we did on Hope. The court asked for the planning commission to review the road. They did, and we came back. And even in that case, they looked at 18 and 20. I mean, it's just a major void here that the planning commission didn't address 18 and 20. It's inexplicable, quite frankly, and I don't know why they did not.
All right, thank you. I think I understand your position. Is there anything more that I need to know to understand your argument?
No, I would reserve rebuttal if necessary.
Okay.
Thank you.
Mr. Bloom. All right, Ms. Coffin.
Thank you, Your Honor.
You don't need to argue anything about the constitutional claims. I take that to be issue preservation. I've already ruled on that.
Thank you. And in terms of aggrieved parties, I heard what you said, but I'm not sure if that applies to all of the plaintiffs in this case. The Saugatuck Dunes Coastal Alliance test is very clear. You had to appear in some capacity and take a position during the underlying case. You have to have some type of property right or interest that could be damaged or injured because of the project. And more specifically, you have to have special damages that are unique or different from anyone else in the general area or county or township. And you have to have evidence of those special damages in the record.
Why isn't that met here? Like now I understand on did they take a position? Some of them did, maybe some of them didn't, but I mean, really, we wouldn't accomplish a whole lot by trying to parse out like, I mean, if any of them did, then this appeal is validly before the court. So, I mean,
If it would be helpful to know if that we have to still deal with 19 plaintiffs, many times when we're talking to plaintiffs' counsel, he cannot respond to us because he has to go to 19 plaintiffs.
right, but why does that matter? I mean, if 4 of these parties are, took a position and 5 of them didn't, then I can still decide whether the special use permit was authorized by law or the findings were supported by competent material evidence. And if I find otherwise, then the fact that there were other additional plaintiffs hanging on is sort of a no harm.
Fair enough.
So getting past the first step, which I think is pretty clearly satisfied by at least some of the plaintiffs, you as much as concede as much. why aren't these folks aggrieved parties when they are property owners next to the development asserting that the development's going to harm them? Isn't the aggrieved party status supposed to target people precisely like that, and not just somebody who lives in Wolverine in Sheboygan County and says, you know, I don't like solar panel farms. I drive past them. I think they're an eyesore. And so I'm going to appeal the issuance of this permit. And the law says, well, you don't have a dog in that fight. But don't these
Because-
folks have a dog in the fight?
They don't know if they have a dog in the fight, because unless they have a specific, it can't just be generalized concern about aesthetics or environmental pollution or things that might happen. If they have an asserted special or unique or of a different scope than everybody else. So to say that I live 0.7 miles away, to say that I have 2 miles away, to say that I have property in the adjoining area, to say that I have any of this is not enough. And there's case law very specifically beyond Saugatuck Dunes Coastal Alliance that talks about that.
Sure.
You cannot just assert.
With those general concerns that very closely mimics the standards that we were looking at with the private nuisance, which I've already ruled that these folks have at least asserted a valid claim to go forward and do discovery for private nuisance. So by you and Northern Waters beating the drum of aggrieved party, isn't that just sort of a mirror image of Mr. Delaney beating the drum of equal protection? Haven't I already kind of
I
resolved
don't,
this?
well, I would.
I mean, you might think I'm wrong. Mr. Delaney thinks I'm wrong on equal protection too. The only thing that everybody in this case seems to agree upon is that I get things wrong.
Fair enough. I think as a municipal attorney that's been doing zoning law for a long time, the issue of aggrieved party status and the narrowing of it through Saugatuck Dunes Coastal Alliance is something that we are looking at, because otherwise every decision a municipality makes is subject to somebody from near or far coming forward and
Well,
saying.
not far.
But then how far?
But isn't
Because these
Saugatuck, you said the
affidavits-
narrowing of Saugatuck. When I read Saugatuck, it seems like a little bit of an expanding where they were saying that, hey, courts, you've been using the aggrieved party rule to prevent people who legitimately should be heard on this. Like, it doesn't have to be somebody who has a real property interest, you know?
Fair enough. We have hung our hats on Saugatuck Dunes Coastal Alliance. I understand your feeling that these parties, at least some of them, may have risen to the level of meeting that test. We argue otherwise, and we, in
Well,
our
who
briefs.
would meet the test? Who would meet the test? If the county planning commission
Mhm.
approves a use that my next door neighbor is going to engage in,
Okay,
and I'm right next door to him, and I'm making allegations that that use is going to interfere with the quiet use and enjoyment of my property. How am I
somebody,
not an aggrieved party?
how is somebody who has a specific injury, okay? And I'm not going to comment on any of the affidavits submitted in this case or anything like that. Somebody who can enunciate why. I've been involved in other litigation where people have been able to bring forward health issues or things like that. That's how I see that test working. All right, I make no prediction as to this particular case in each of the 19 plaintiffs. But if somebody is just generally saying this could rise to the level of harm such that there could be pollution, there could be property value damage, there could be additional traffic, there could be, and I live within a certain distance, I don't know what that distance is. I don't think that rises to the level of an aggrieved party. I think there has to be more particular.
Give me an example of something that does rise to the level of aggrieved party in your mind.
I had a case in West Michigan on a wind turbine. It was approved. The lady next door had put in the record all along the way that she had a seizure disability from stroking, and the flashing lights, the flicker, shadow flicker from the turbines on her house, which was adjacent, I believe would rise to the level of being able to announce an injury. Now, that was a case was before Saugatuck Dunes Coastal Alliance. And as the municipal attorney in that case, again, it was a different test at the time on aggrieved party status, but that would be something, and that was announced throughout the process. She made it known that I have concerns because I have this medical condition. And when those turbines turn and that flicker goes on my house, I don't know what's going to happen to me. There you go. There you go. So, that in my personal opinion is in one case where I saw it was proved up.
Okay.
More importantly though, moving past that, because I understand Your Honor is going to take all those arguments under consideration. I call everyone's attention to section 17.32.2 of the zoning ordinance, which says, any solar energy facility with a nameplate capacity of 50 megawatts or more shall be a permitted use by right in the following zoning districts: commercial development, agricultural, forestry management, lake stream protection, light industrial development. That is why the staff report does not implicate section 18. That is why this is a permitted use. If there's any harm, it's that we gave more process than needed than required by law. We gave more notice, we gave more opportunity for public hearing, we gave more ability for the neighbors, the residents, the citizens to be involved. It is a permitted use.
Well, that's not, I mean, that's like a new position that the county would be taking.
No, it is not a new
Because
position.
what was issued was a special use permit, was it not?
But in all
Was
of
it
the
not?
briefing, I believe
I'd like an
there was
answer to my
some,
question.
I believe there was some version of a special use permit.
Okay.
Yes,
So
but
we're
the reason.
reviewing an appeal of the issuance of a special use permit. Is that correct?
Yes,
Okay. So if the special use permit was not properly issued under the special use permit procedures, should it be set aside or not?
no, because it was a permitted use. And even if you go back and look at the minutes from the meetings, I don't remember if it was the one at the high school or the Opera House, I specifically said in the record, this is a permitted use.
You're not the planning commission. What you say is not a finding.
Okay,
The findings of the planning commission are not, this is a permitted use, end of story, are they?
the findings are, these are the standards that have to be satisfied.
You
and
haven't
this
answered my
is-
question.
The question is,
Did the planning commission make as a finding, well, this is a permitted use, so we're
I
done.
would have to go back and look at the staff report.
Well, of course they
which they
didn't.
incorporated.
Of course they didn't. They went through, and considered all these different standards.
But plaintiff's attorney's argument is they didn't consider section 18, and that is fatal. And I'm saying it's not fatal. Because all they had to do was find that it met the standards of 17.32, which they did. That's what a CREO is.
Well, but I have to look at, and the planning commission is bound by the entire ordinance, isn't it?
What section 17.32 says is if you are a solar energy facility of 50 megawatts or larger, these standards apply to you. And as the reason why 17.30 remains after 17.3032 was repealed is because there could be projects smaller than 50 megawatts. And in those cases, 17.30 still applies. So the reason why is somehow people believe this was a special use permit. It was brought in as a special use permit. It was noticed as a special use permit. All I did was read the ordinance and it says it's permitted use.
So then why are we even on appeal here?
I'm not sure.
Well, but you're taking a position today that seems contrary to the position of the planning commission. They evaluated an application for a special use permit and granted it. So I don't know how in the world I can say, well, they didn't even need to do any of that, so nobody gets to appeal from it.
They didn't need to do any of it, but they did. And once they started it, they gave the process to the citizens and they allowed them to participate. But it would be unfair to throw out the whole thing simply because they didn't follow section 18, which they didn't have to.
Okay, I completely disagree with that position. So why don't you explain to me why the special use permit issued was properly issued? Not that it didn't need to be issued, but tell me why it should have been issued.
We do argue, as we did in our brief, that on the record as a whole, with the application, the minutes, the staff reports, all of the analysis.
Hey, can I ask you, let me back up a minute, because then Article 10, Lake and Stream Protection District, which this project is in, at least partially in that, right?
I believe so, yes.
Okay. Section 10.3.3. Let me get this right, because Mr. Delaney kind of laid this out. I'm sorry, 10.3.16. 10.3 says uses requiring special land use permits. And 10.3.16 says level 3 SES PV systems in accordance with section 17.30.6.c. Isn't that still part of that is still part of the Sheboygan zoning ordinance? So don't they have to get a special use permit? And that's why they went through all this?
Okay, level 3, 17.30.6 says, yes, special use permit, all of the following here. All level 3 SES PV systems have to follow these things. And then we go over to, sorry, turning pages back again. 17.32. The purpose of this section is to regulate any solar energy facility with a nameplate capacity of 50 megawatts or more. So it takes us, it's a subset of 17.30.6. When you get to the solar energy facilities with more than 50 megawatts, you're going under this section.
But your position seems to require me to read several sections of the Sheboygan County zoning ordinance and say they're invalid. 10.3.16 that says these level 3 systems require special land use permit. Not true. Why do I have the authority to do that?
It's under section 10. These are special uses. You go and then you read section 17.30.6.
Which are supplemental regulations.
Yes, and you
not
go
substitute regulations.
You go over their supplemental. You read that section.
Supplemental
says,
would generally mean in addition to, not instead of, wouldn't it?
It would, but if you read, when we change the definitions, and this amended 186, of course, section 10 was back in sometime before they added the new one, the CREO. And in the CREO, they carved out, I guess that's the best way to say it, they carved out the projects that are larger because of Public Act 233, okay?
But they didn't amend all those other parts to carve those out.
No, they didn't. They added this.
So all those other provisions point to you have to get a special use permit, which I presume is why Northern Water's lawyers looking at this said, let's apply for a special use permit, people. Look at this ordinance all over the place. We got to go this route.
In general,
if you were a lawyer, I mean, if any of us were a lawyer for Northern Waters looking at this ordinance, we would certainly apply for a special use permit, wouldn't you? I mean, well, you see all these things that say you have to in the ordinance.
I'm sure they will answer for themselves.
Okay.
But generally.
So let me ask you then, if I'm persuaded that the Planning Commission was required to also consider Article 18's findings, does that mean you're conceding they did not and you would lose? That your argument is that they didn't even have to consider 18?
Well, I believe that on the whole record, if you do look at it, they did discuss at length the application, the staff reports, the submissions. There were various supplemental reports submitted with the application. There was all kinds of information submitted by the citizens. All of it was considered. So if in fact there's any question on whether they properly reviewed all that, then we would, I guess, request a remand. In general, the plain language of the statute controls, which is the same analysis for zoning ordinances. And 17.32 just clearly says it's a permitted use. And I don't know how we get around that. I don't know how the Planning Commission is punished for following that law. I don't know why we're on appeal here, but we are. And this is not the first time we've brought this up in our position in front of the court. It was I stated in the public meetings. Anyone who's at the public meetings would have heard me state it. It's in the minutes of the public meetings.
I guess, can you point to me in your brief on appeal where you made this argument? Because I don't recall it. Your argument on appeal is that they're not aggrieved parties and that they have failed to demonstrate that the Planning Commission's decision was not authorized by law or supported by.
It may not be in our brief on appeal, but it was in the brief on summary disposition, the initial brief we brought for summary disposition where we also addressed this issue. We're not trying to, fool the court or not be forthright. This has been brought out all the way along.
Right, but you're arguing a position today that is not your written brief on appeal.
It could be.
Could be. Will you just answer my questions, please?
Your Honor,
Show me in your brief where you raised this issue.
Michael wrote the brief, so I'm going to assume, yes, you're correct. It's not in the brief.
Okay, maybe Michael should be arguing. All right. Anything else I need to know to understand your position?
No, thank you, Your Honor.
All right. Mr. Opolewski, go ahead, sir.
Yes, thank you, Your Honor. Your Honor, I've heard you and your discussion on the aggrieved party standard. I would like to make a few comments on that just for the record. So as Your Honor noted, the vast majority of the appellants in this case did not participate at the Planning Commission, but there is no dispute that I think it was at least 4 of them did. So Your Honor has elucidated your position that you're going to move forward if at least one of them meets that first standard.
Well, can you ask me can you answer for me what would be the alternatives? So if at least one of them did, then this is not grabbing me. If at least one of them did, then what benefit would we have in sort of parsing out which ones did not? Because if one of these several plaintiffs appellees are an aggrieved party, then we can consider the merits of the appeal, right? So I guess I'm just asking, so if you could demonstrate that, or if I could rule that 5 of these plaintiff appellees were not aggrieved parties, what relief, what would that do for you?
So, Your Honor, you're right. If at least one of the appellants can satisfy all 3 aggrieved party standards, then you would still reach the merits. I agree with that position. What I'm arguing here, starting with the first Saugatuck Dunes criteria, is that the only 4 that satisfy that first criteria can be considered with the following 2. And really what I want to focus on here is the third criteria, and that is that you have to provide some evidence of special damages arising out of the decision. And that needs to be in the form of effects that are more significant in degree than others in the local community. And all we have here, Your Honor, are these affidavits, which were plainly copied and pasted from each other, which I think in and of itself is an admission that there's nothing special about any of these properties as it relates to the project. And it was discussed that, well, if my neighbor is putting up a project that was approved by the Planning Commission, don't I have standing to then appeal that? And the Supreme Court answered that question, Your Honor. In Saugatuck Dunes, it says just neighboring property ownership is not sufficient to meet the aggrieved party standard. You have to show special damages. And plaintiff's counsel, or appellant's counsel rather, introduced the Tuscola case. And in the Tuscola case, what we had there was actual evidence down to the specific dollar amount, which would be impacted by the project. I think it was $262 that the airport said they would lose as a result of the project that was approved. We have nothing even approaching that here. We have something that looks like it might have been pulled off of Google that says, what are the top 5 concerns of a solar development? Your Honor, that's plainly not sufficient to meet the aggrieved party standard, in our opinion. As to the merits, Your Honor, I've looked at this case as we all have, and frankly, if this record, which has hundreds of pages of expert testimony supporting the application, is not sufficient to support a special land use decision, I'm not really sure what is. And I think what I heard from appellant's counsel is that they're not really challenging the evidentiary support for the approval, which I don't think
they're not challenging at least in the briefs and arguments made here, they have not challenged the sufficiency of the findings that were made in the Planning Commission's report regarding Article 17 stuff. But what am I to make of this argument that there were other standards that the zoning ordinance requires to be met, specifically section 18.7 B and C, that the Planning Commission was silent about? Are they right, and what effect should that have?
Well, I don't think they're right, Your Honor. The case that we're relying on for this line of thinking is the J.S. Beck case. And this could not be a more different case than the J.S. Beck case, Your Honor. As I'm sure Your Honor knows and is familiar with that case, the Planning Commission, the deciding body, didn't even issue findings of fact. And that's why it was remanded, not because it wasn't in the specific format that the appellants wanted. The appellants don't have a right to findings of fact that are formatted in the way that they would like. What is required under the law is findings of fact that are sufficient to inform the court about the evidentiary basis of the planning body's decision, so that way the court can conduct the substantial evidence test. The statement of findings and conclusion is not in and of itself the holy grail of this argument. It's more so a roadmap so that the court can evaluate the substantial evidence test that's provided in the court rule. And what I would say is that here, Your Honor, the Planning Commission made dozens of findings of fact that are supported by pinpoint citations to the record. You know, I know we've all done a lot of these cases, as we've all discussed. I've been doing land use and zoning for over a decade, Your Honor. This is in the top 5% of findings and conclusions that I've had to litigate. And it's lost on me as to how appellants can claim, well, okay, Articles 18 and 20 were at play here, and you can't review the whole record and understand how those aren't met. I would argue the exact opposite, Your Honor. The application specifically addressed each and every detail that was required by Articles 18 and 20, and the application is referenced specifically by the Planning Commission in their findings of fact. So that's in the whole record. And even more than that, Your Honor, the findings of fact specifically make reference to Section 17.32.6a, which incorporates the voluntary requirements and conditions that Northern Waters met. And those incorporate Section 17.30.3, which says, in addition to the requirements of Articles 18 and 20. So the Planning Commission did actually lay out a roadmap for saying, look, there's a record here, hundreds of pages of expert testimony as to how all these requirements are met. Here's the ordinance sections that say that they're met, and here's the evidence that supports that. Really, Your Honor, I'm at a loss for which of the site plan standards or which of the special use standards that appellants say that we haven't met, because I haven't heard one yet.
Well, but I think their position is that then what you're asking me to do is look at the evidentiary record and myself make findings under 18.7. And I don't have the authority to do that, do I? I mean, I review findings that were made, but if there were findings required to be made under Article 18 and there were none, you're saying that's not fatal to the permit, that I can nonetheless decide that those standards were satisfied. How is that me not making in my own finding?
Your Honor, I fully agree with you that the circuit courts are not imbued with the power to make their own findings. I think we can all agree on that. What I would say, though, is that the court rule requires a review of the whole record, referencing the findings that were made by the Planning Commission. And here, the Planning Commission makes reference to the zoning ordinance sections I just stated, which incorporate the special land use and site plan standards. And they make pinpoint references to the application materials that satisfy those. Again, this is not a case where, like J.S. Beck, there were no findings of fact made. This is a case where there's voluminous, it'd probably be a 6-inch thick record if you printed it out. There are voluminous findings. There are voluminous evidence to support each one.
I'm old fashioned, so I don't read everything on the screen. So I do have the whole record printed out, and it's thicker than 6 inches.
Well, there you go, Your Honor. But again, to get back to your question, we're not asking you to make your own findings. I agree with you that would be improper. What we're asking you to do is what the law requires, which is to review the whole record with using the findings and conclusions as a guidepost. Again, the findings are not this holy grail. The findings and conclusions document, rather, is not this holy grail where you live and die on. It's the roadmap to provide the court with the knowledge to know, okay, when I review the whole record as I'm required to under the court rule, were these standards satisfied? And we say that yes, they absolutely were for the special land use, Your Honor.
So is it Northern Water's contention that the Article 18 standards did have to be satisfied, but that they were? Because I'm hearing today from the county that those standards just simply were inapplicable. What says Northern Waters about that?
So Northern Water's position, Your Honor, is that this was a use that was permitted by right, as it had to be under the CREO. However, we had the option to comply with additional voluntary standards, which would give us the special land use approval. We applied for a special land use. We submitted the application fee for a special land use. We attended the public hearing, which is required for the special land use. And I think it's as very clear on the whole record, which is what the court rule and the case law requires, that we do satisfy the Article 18 and 20 site plan and special land use requirements.
So am I allowed to review the standards of whether a special use permit should have been granted then? If that's what you applied for, isn't that what I'm reviewing?
You would be reviewing the whole record to see whether or not we satisfied those standards, which I think even a cursory review of the record would show that we absolutely did, Your Honor.
Okay. All right, thank you. Anything else I need to know to understand your position, sir?
If Your Honor is inclined to remand the case, which again, we would strongly argue otherwise, our position would be that any such remand would be limited to the ordinance that was in place at the time and then the evidence that was already on the record.
Okay, thank you. Mr. Delaney, any rebuttal arguments, sir?
Briefly, if I could, I think the court has a good handle on this and gave the attorneys an opportunity to state their position. Let's talk about MCR 7.122. And I'm looking at it and I'm reading from it. It's the last sentence. The findings were supported by competent material and substantial evidence on the whole record. It doesn't say that the whole record was supported by competent material and substantial evidence. They're reversing the language. So that's the key provision, that the findings, and there simply were no findings in this case. Now, as to this use by right special use permit argument, the county is up against three notable indisputable facts. The notice of public hearing, which the court has printed, says it's a special use permit. That went to the public. They read that in the newspaper. They went to the meeting. The agenda says it's a special use permit. The minutes, and this is for both the July and the August meetings, says special use permit. The public has every right to rely on that, read the ordinance, read 9 and 10 that are subject to 18, read 18 and read 20. Now, the brief of EDP, page 3, right off the bat, in the first paragraph, says the application states on its face that NW, Northern Waters, submitted its review pursuant to the Sheboygan County zoning ordinance, Articles 20 and 18. I mean,
which they just did. I mean, I'm looking at their application.
Yeah, it's in their application. It's in their brief. This is on the use by right, which was raised sort of sua sponte. This is from the brief of the county, page 1, second paragraph. Northern Waters applied for a special use permit. I mean, so it's just really uncontested that that's what it was. And as soon as they do that, particularly putting the public on notice that it's a special use permit, the applicant admits it, it's in the newspaper, it's in the agenda, and it's in the minutes. And as soon as you do that, you must apply 18 and 20. And I think that that's really indisputable. And I want to close because I think the court has a very good handle on this position. We all took note of the court's hero was Antonin Scalia. Mine was Rehnquist. And I like Justice Gorsuch, what he's doing with agencies. But, and I put this in my brief, that if Congress enacts a law, something different from what they intended, it's up to them to amend the statute. In the meantime, the court has no roving license to disregard clear language simply on the view that Congress must have intended something broader. Great restraint by Justice Scalia, great restraint in his adjudication of cases. So I've converted that into a sentence. If Sheboygan County amended Section 17 of the Sheboygan County zoning ordinance and intended to amend 9, 10, 18, and 20, it should amend the zoning ordinance to conform to its intent. The circuit court has no roving license to disregard the clear language of the zoning ordinance, simply on the view that Sheboygan County must have intended something different.
Thank you. Well, this is an appeal from a decision of the Planning Commission, which was a decision on application for a special use permit by defendant intervening appellee Northern Waters. I'll initially comment that I'm rejecting the plaintiff appellant's position with regard to the constitutional claims for equal protection for the same reasons that I dismissed those counts from the civil action. I think the parsing out of zoning districts is not a violation of equal protection, and the fact that uses are permitted in some and not others doesn't violate anybody's equal protection rights, or to the extent any equal protection claim was presented and be reviewed on rational basis scrutiny. I don't see any grounds for relief on equal protection. So really the first question here today is, are the plaintiffs aggrieved parties? Do they have standing under the Saugatuck Dunes three-part test? I think the answer to that is that yes, they do. This appeal is part of a broader civil action that was filed. It's count 10 of a complaint brought by several of the plaintiffs. As conceded by the appellees today, at least some of those plaintiffs did participate in the challenge proceedings by taking a position on the contested proposal. So the first prong, as to the first prong, did they take a position? Yeah, they did. Now, some did and maybe some did not, but if any of them did, then the merits of the appeal, if they satisfy the other two prongs, would be before the court. In its brief, it's not really argued today at oral argument, but it is in the brief. Northern Waters seems to suggest this is an issue preservation requirement, saying that those folks did not take precisely the same position at the Planning Commission that they take on appeal. But I don't read Saugatuck Dunes as requiring that. It's not an issue preservation requirement, it's a standing requirement. So there are at least some of the plaintiffs' appellees that did take a position below. As to the second and third prong, protected interest in special harm, these plaintiff appellees are adjoining landowners who have asserted in this litigation various possible harms to them and their property from the proposed special land use. That's all I believe that Saugatuck Dunes requires. That decision, in fact, expanded the definition of aggrieved parties, which used to be limited to real property owners. Here, plaintiffs are indeed real property owners who allege likely harm from the proposed use. Their allegations are very different in kind from those of general people in the community. I mean, Saugatuck Dunes would, for example, prevent somebody who lived, in a completely different area of the county, who is just generally opposed to renewable energy or solar farms, how they look or where they ought to be. That person doesn't get to appeal just because they don't like it. Saugatuck Dunes would say, you're not an aggrieved party. This isn't really going to impact you. You don't have a say in what's going on. But here, these folks are alleging property interests that would be harmed because they are adjacent to or right nearby this proposed fairly extensive development. And this court has already held that these plaintiffs have stated a valid claim for private nuisance arising from the proposed special use. I understand that Northern Waters is seeking interlocutory review of that decision, but it would indeed be quite a strange result for the same court to simultaneously hold that they have validly stated a claim for private nuisance, but they have no standing to appeal the issuance of the special use permit. So I do believe on this record, and I guess I haven't addressed the issue about the affidavits to establish the special harm. There's no clear-cut answer in the case law on that. You don't get to expand the record on appeal, but there's no attempt to expand the record on appeal for review of the substantive decision. But how would in a zoning appeal, people who are appealing establish that they are aggrieved parties? So I think the affidavits establishing the harms, I don't take to be improper, and I have in fact considered them. As Mr. Delaney articulated, they're not an aggrieved party until there's a decision. Are you aggrieved by that decision? So they're not going to, before the decision, explain to the body, here's the harms that that make me an aggrieved party from the decision. So I think on that standing question, there has to be some opportunity for appellants in a zoning appeal to establish that they're aggrieved parties if it's challenged by the appellee. So I think they meet the aggrieved party standard, which I don't think is a particularly high threshold. It's just a standing. Like, do these folks have a say in what's happening? And I think they do. So then on the merits of the Planning Commission decision, the Zoning Enabling Act requires that the Planning Commission make written findings, and the Sheboygan zoning ordinance requires specific written findings. The zoning ordinance for the districts that this proposed use is in specifically say that you have to apply for a special use permit. And that has sections, or Article 18 and Article 18 for special use permit procedures and standards, and then Article 20 for site plan review. And then there's this Article 17, which is supplemental regulations and standards. Supplement means, a supplemental standard means in addition to, it doesn't mean instead of. So reading I know that the county today presses an argument that caught me a little off guard because it wasn't in the written brief anywhere that I can find, that they didn't even need to do a special use permit. And so they didn't need to do any of this. But they did. There's an application, Northern Water's application is for a special use permit specifically and explicitly under sections 18, 20, and 17. And their application explains why they meet certain standards in Article 18, specifically Article 18.7, B and C require the following, they have the following standards. The proposed special land use will not involve uses, activities, processes, materials, or equipment that will create a substantially negative impact on the natural resources of the county or the natural environment as a whole. Subsection C provides the proposed special land use will not involve uses, activities, processes, materials, or equipment or hours of operation that will create a substantially negative impact on other conforming properties in the area by reason of traffic, noise, smoke, fumes, glares, odors, or the accumulation of scrap metal that can be seen from any public or private highway or seen from any adjoining land owned by another person. Northern Water's application to the Planning Commission explains specifically and by reference to that specific language why their proposed land use satisfies the standards of section 18.7B and 18.7C. The notice of public hearing to the public says that this is that the applicant is requesting a special use permit, EDP Renewables, which is apparently the parent company of Northern Waters. So this is clearly an application for special use permit. And this is what the public is commenting on and what the Planning Commission is considering. And then they make written findings of fact as required by the Zoning Enabling Act and by the zoning ordinance. They make some general findings of fact And then they make specific findings of fact as to the Article 17 standards. Completely omitted from those findings are any standards as to whether the requirements of Article 18 are met, specifically 18.7 sub B and sub C. And the county today says, well, that's not necessary because there didn't need to be a single finding because this is just a permitted use. And again, that wasn't in the brief. And that argument doesn't even make a whole lot of sense to me because there was an application for a special use permit, it's granted and appealed from. That's what I'm reviewing. Then the Northern Waters says, well, the Planning Commission didn't make any findings about Articles 18.7 B and C, but that's just a matter of format, and that I should review this inches upon inches of expert information for me to determine that those standards were nonetheless met. That's not what the court rule requires me to do, and it's not what I'm empowered or even well equipped to do. How would I know? The 7.122 refers to my review of whether the decision was authorized by law and whether the findings were supported by competent material and substantial evidence on the whole record. I'm supposed to review the decision and its findings. And section 18.7 says the Planning Commission shall approve or approve with conditions an application for special land use permit only upon a finding that the proposed special land use complies with all the following standards. And then there's B and C that I've outlined. It doesn't, for example, say that the Planning Commission can grant a special use permit if it doesn't interfere with, and then put those standards out. It just doesn't say you can grant it if those standards are satisfied. It says you can only grant a permit upon a finding that those standards were satisfied. So I understand the frustration of the appellees here, that there was a lot of work put into this application and that those standards may well be met. I have no idea. And that this is at one, maybe on first blush, this is a technical matter, but the ordinance requires what it requires. And, if Sheboygan County was intending that this use didn't even need a special use permit and Articles 18 and 20 had no bearing at all, then their ordinance does not say so. They would need to make it much more clear than that. And I presume the lawyers for EDP and Northern Waters looked at this and said, man, we better apply for a special use permit. And that's what they did. There simply are no findings under Article 18 that would support this decision. So therefore, the Planning Commission decision here was not authorized by law, that law being the Zoning Enabling Act and or the Sheboygan zoning ordinance, and or its findings and decision is not supported by competent material evidence on the whole record because of the failure to make those requisite findings. Therefore, I think the proper remedy for me is to reverse that decision and vacate the special use permit that was issued. So I'll prepare an order and get that entered today. I think that's only going to leave count 6, the private nuisance claim that is currently stayed pending appeal. So that my order today won't be a final order that closes the case, but Sheboygan County's out of the case in this court. And the only parties left would be the plaintiffs and Northern Waters on count 6, which is stayed, and it'll remain stayed until we get a decision from the Court of Appeals or some other stipulation or motion from the parties. All right, anything further from the plaintiffs?
No, I'm just confirming what the court just said, that this order on the appeal would not be a final order.
Well, it's not a final order in this case. I mean, I've expressed before the fact that an appeal is contained in a count in a civil action, I think raises some procedural complications. So for example, if the county or Northern Waters wishes to seek appeal to the Court of Appeals from this court's decision, would that be by leave or by right anyway? It'd be by leave anyway.
I believe
I think it
at this
might
point
be.
be by leave.
Yes.
Yeah, so it doesn't matter whether it's final or not. So,
In Saugatuck, if I could just jump in.
Well,
for a
that doesn't-
moment, Saugatuck was that situation. Saugatuck was, they put the appeal in with the original action of the court. Because at the end of the decision, they say, well, you can still rule on the original actions. But it's a little more complicated than that because there were multiple appeals, but in any event, okay, I think that's,
Okay.
the court will indicate.
yeah,
it's
and
not a
in
final order.
terms of how the planning commission or the parties proceed, you know, after this court's ruling, I'm not going to micromanage what happens then. Mr. Opalewski has expressed some opinion about that. That's for the parties to argue about and sort out below. All right, thank you all very much for the adjournment.
Thank you, Your Honor.
Thank you.
Your Honor.
The corporate suits marched in with